Okay, so we've talked a little bit about equal protection, about how a group becomes a suspect class. We've talked about the grid of classifications and how you handle each one of those. It's time to start talking about some cases and running through these as though they're exam fact patterns to see how you do the full analysis. We're going to start with the Railway Express case, which is on page 1351, Railway Express Agency versus New York. This has to do with New York City regulation, so we have state action. The regulation bars, essentially what's going on here is that if you own a truck, you're not allowed to sell advertising on the side of your truck. The only advertising on the side of your truck can be advertising for your own company, your own business. So essentially you're not allowed to use your truck as a billboard, right? You're not allowed to sell billboard space on your truck. Now, you might ask yourself, why in the world is this an equal protection case? Well, you have to look at the dates, 1949. So we are post-Lochner. Remember that? Right, there was a time when economic rights were considered fundamental. The right to contract was considered fundamental under Lochner versus New York, but Lochner was overruled in Nebbia, and you'll recall Lee Optical, right? I mean, Lochner is super overruled. So at this point in 1949, lawyers knew that a substantive due process claim based on it, some kind of economic right, and certainly if there's any right involved here, it would be an economic right, the right to sell advertising on the side of your truck, right? Advertising that doesn't have to do with your own business. That's going to get you nowhere. Now, as we're going to see, the Equal Protection Clause gets you equally nowhere, but you understand why the lawyers here didn't raise a substantive due process claim, because we are post-Lochner, we are in the post-Lochner era, and they just knew that was a non-starter. So instead they say, this isn't fair, right? This is some kind of arbitrary treatment. There's no good reason why you should be able to advertise your own business on the side of your truck, but you're not allowed to sell advertising for other businesses. So pretend that it's not 1949. Pretend it's 2020 and that this is an exam fact pattern. That's the way you always want to read cases. How would you deal with these facts on an exam? And so under equal protection analysis, first of all, you cite your text. So it's New York, so you know that the text is the 14th Amendment, right, which applies to states, and that once again, states include subdivisions of states. So there's no question the 14th Amendment, the Equal Protection Clause, applies to New York, and we're off to the races. And the question is, has the court, because first you always check when you find your classification, right? Has the court already said that's a suspect class? And if so, you go straight to the level of scrutiny. And by the way, if the court has already said definitively that's not a suspect class, you go straight to the level of scrutiny. So what's our class, right? You have to identify when you're doing an analysis, what's your class? Well, this is a ridiculous classification. I mean, in terms of trying to argue that it should be suspect, or it is suspect. The classification is business owners, people who own trucks, who want to sell advertising on the sides of their trucks. That's your group. You can't fight it. I mean, that's the group. That is the classification. This law targets people who own trucks who want to sell advertising on the sides of their trucks. Okay, that's your group. Has the Supreme Court ever said that that's a suspect class? You see, at the time, the lawyers were thinking maybe we can make some kind of an argument based on arbitrary treatment, but under modern standards, this would go pretty quick on an exam, right? No, of course not. The Supreme Court has never said that people who own trucks and want to sell advertising is a suspect class. Next question, should it be a suspect class? Don't forget to look at that when you're doing a complete analysis, meaning if this was an essay question, right? If this was a multiple choice question, you would just immediately go to rational basis review because it's a non-suspect class. But if I was to ask you an essay question on this, you'd have to go through the whole analysis. Should this be a suspect class? Is it an immutable characteristic? Remember your factors. Is it an immutable characteristic to be a truck owner? Were you born that way? Is this something innate that can't be changed? Is this something like somebody's ethnicity or gender? Of course it isn't. You would be writing this down. It's not like those other things. It's not an immutable characteristic. It is changeable. it involves conduct, it's not an immutable characteristic. Do we have a history of political powerlessness here? Do we have a long national history of targeting people who own trucks? Think about that. We're talking here about business owners. Business owners. Is that a politically disadvantaged group in American history? I mean, that's ludicrous. Obviously not. We're talking here about people who have money, who own businesses. There's no history of political powerlessness. Now, I've mentioned before that in some cases, it's easy to see how that third factor applies, ability to contribute, and in other cases, it's hard to see how it applies at all. In this case, the issue would be whether being a truck owner who wants to sell advertising has anything to do with somebody's ability to contribute to society. That's what the deep issue is here, right? Because the rule trigger is able to contribute, right? This characteristic affect ability to contribute. That's the rule trigger. The facts are, the characteristic here is people who own trucks who want to sell advertising. So your deep issue is whether people who own trucks who want to sell advertising on their trucks, whether that characteristic has anything to do with a person's ability to contribute. So sometimes it's easy. Again, if you're talking a height restriction for a pilot, then you see that there's a logical way to apply this, right? Height has something to do with the ability to contribute. If you're talking about something that clearly is an immutable characteristic, like somebody's gender or somebody's ethnicity, then it's also easy to see, right? That there's no relationship there's no relationship at all between somebody's ethnicity, somebody's gender, and their ability to contribute to society in any conceivable way. So sometimes it's easy to see how it applies. If you look at the fact pattern and you kind of develop a deep issue in your head and you say, I don't even see how this applies in this case, then don't worry about it. Just say this is the third factor courts look at. In this case, it doesn't seem like it would even apply. That's fine. So that's when you go through those three factors, there's nothing about any of those three factors that cuts in favor of finding a suspect classification here. So this is one of those cases where I tell you that it's not about outcomes and conclusions, but boy, if you were going to say this is a suspect class, that's fine, but you better have one good argument for that. Most rational people are going to conclude this not a suspect class. That you're not done yet, right? If it's not a suspect class, remember this when you take your exam. If it's not a suspect class, because I see this all the time. Oh, this is not a suspect class. The law is valid. Oops, you forgot something, right? If it's not a suspect class, that means you go to rational basis review. So you have to state the rule. Under rational basis review, the challenger, here the owners who want to sell advertising, they would have to show that either there's no legitimate interest or that the means are completely irrational. So what's the government's interest here? You have to be able to identify that from the fact pattern. Pause the video for a minute and think about that. Why does New York have this rule? What's the interest? Okay, and so you should have concluded safety, highway safety, traffic safety. New York argues they're trying to reduce distractions, right? And so, so people pay attention to the road, and so that's the interest. So now the question is that a legitimate interest? Is traffic safety a legitimate interest? Of course it is. That health and safety, save the children, saving lives. It's beyond legitimate. All it has to be is legitimate. It's arguably well more than that. The real issue here is whether the means have any impact on it, right? Are the means rationally related to achieving the interest? Now this is why it's so important what tests we're applying. If we were applying strict scrutiny here, this law would fail. Because stopping people from selling advertising to other businesses when they're still allowed to put their own signs and ads on the truck doesn't seem like it's the best possible way to reduce distractions. There might be many better ways to reduce distractions. And so if we were applying heightened scrutiny to this, whether it be intermediate or strict scrutiny, probably would have a court second guessing this and saying this is kind of silly, and maybe striking it down, certainly under strict scrutiny and probably under intermediate. The point is, those aren't the levels of scrutiny that apply. The level of scrutiny that applies here is the one the government wants. Remember we talked about that? The government wants rational basis review, they get it. And the court says, look, this may be a silly ordinance, but might it reduce the distractions a little bit? Maybe it will. And so as long as that's the case, we find that a law is rationally related to a legitimate interest, and the law is upheld. The same idea in New Orleans versus Dukes on page 1353, where the issue here is pushcart vendors now, and in the French Quarter, or would-be pushcart vendors in the French Quarter of New Orleans. And unless you're grandfathered in, you're not allowed to have a push cart and operate a push cart in the French Quarter of New Orleans. New Orleans is a city; it's a subdivision of a state. The 14th Amendment clearly applies. The Equal Protection Clause is in the 14th Amendment, so it applies. Okay, so we've settled that. Now, identify the class. Well, the class is would-be pushcart vendors, right, who are not grandfathered in under the New Orleans ordinance. Has the Supreme Court ever said that that's a suspect class? No, it's ludicrous. Of course, they haven't said pushcart vendors, or people who want to be pushcart vendors is a suspect class. No. So should it be a suspect class? Well, is a would-be pushcart vendor, right, is that an immutable characteristic? Again, to ask the question is to answer it. It's ludicrous. You know, you're not born a pushcart vendor. It's not something innate and unchangeable. It's a choice. You know, I mean, I suppose you could make some kind of argument, right? I was born with a dream to be a pushcart vendor. It's not going to fly. So, no unimmutable characteristic. History of political powerlessness. There's no history one way or the other. I mean, pushcart vendors. No, not a lot of laws on the books about pushcart vendors. It's certainly not one of the groups that's been targeted for sport throughout our history. So that's going nowhere. And we're back to this again. Ability to contribute. Does being a would-be pushcart vendor, does that characteristic affect somebody's ability to contribute to society? Once again, I would tell you, I don't even understand that question. We're back to one of these cases where that third factor doesn't even seem to apply, so you just note that and move on. Once again, you're not done. If this is an exam question fact pattern, you say, I've concluded that it's a non-suspect class, therefore I apply a rational basis review. You have to identify who has the burden under rational basis review. That would be the challenger, that would be pushcart vendors. What burden do they have? They have to show no legitimate interest. What's the city's interest? Once again, feel free to pause this for a minute and think about it. Okay, the city's interest is aesthetics. We want the place to look nice. It's the French Quarter. It's a tourist area, right? And so we want the place to look nice. Aesthetics would be your typical example of an interest that is not compelling and not important. And again, this emphasizes the point. It matters what test you're applying. You're not asking whether aesthetics is a compelling interest. You're asking whether, in a tourist area, whether it is a legitimate interest to keep the place looking nice. And the court says, yeah, it's legitimate. So the remaining question is whether limiting the number of push carts in the French Quarter is rational. A rational way to achieve the interest being keep the place looking nice. These means, ends, means, ends. And the court says, well, I mean, what's the problem with push carts? Okay, first of all, they're unsightly to begin with, they're ugly. So the more of them you have, the less attractive the area is. Besides that, they sell food and condiments, right? And so you got mustard stains and ketchup stains all over the sidewalk and blah, 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 blah. We're applying rational basis. Is it a rational, sane way? Is there maybe some relationship at all between limiting the number of push carts and making the place look nice? And the court says, yeah, we buy that. So once again, the ordinance is upheld. So there you see a couple examples of how to run through the entire analysis. When it comes to fact pattern on an essay, both of these lead us to conclude, these fact patterns would lead us to conclude that we're dealing with non-suspect classes and that the laws at issue, they meet the rational basis standard. So that's enough for this short video. We'll keep moving on through the cases. But I hope that this was a good exercise in application, how to do a full analysis of an equal protection question. Of course, there are more nuances to it, but up to this point, how to do a full analysis of an equal protection question. So stay well and stay tuned.